Good afternoon and welcome to the Law and Crime Report. I'm Angelica Spanos. Thanks for joining us. The show where we dive into all top legal stories and true crime headlines making headlines today. First up, a police officer in Ohio will face charges after killing an unarmed black man. Andre Hill was shot by a cop walking out of a garage on his cell phone back in December. Former police officer Adam Coy responded to a report of a man sitting in his car for a long time. And body camera footage later revealed that Coy shot Hill within seconds of their encounter in that garage. Here's the Ohio Attorney General describing the attack against Hill.
After a brief interaction with the man, Andre Hill, Officer Coy stated that he thought he saw a gun in Hill's right hand and fired his service weapon, killing Hill. He was 47 years old. No weapon was found on the scene. The Ohio Bureau of Investigation and Identification, a division of the Ohio Attorney General's office, performed the investigation at the request of the city of Columbus. BCI's investigation, including the process of the crime scene, gathering and evaluating evidence, reviewing body cam footage, and analyzing cyber data, as well as interviewing witnesses, including the officers involved in the incident. BCI's investigation is typically turned over when it is complete to the prosecutor having jurisdiction. The prosecutor, in turn, makes a presentation to the grand jury, which makes the decision about whether or not to indict an individual. As an independent fact finder, BCI's investigators only present the facts. They do not determine whether an officer's use of force is justified. Today, the Franklin County Grand Jury indicted Mr. Coy on the following charges: murder and the commission of a felony, that felony being felonious assault, a separate charge of felonious assault, one count of dereliction of duty based on Mr. Coy's failure to engage his body camera, and one count of dereliction of duty based on his failure to inform his fellow officer that he felt that Mr. Hill presented a danger. The grand jury was also instructed on purposeful murder under Ohio law, and they issued a no bill as to that charge. Coy was arrested earlier this evening on these charges. He will have his initial appearance in court tomorrow. A bail hearing will be conducted at that time. Law enforcement officers are held in high regard because of their sacrifice, their courage, their service to our communities. They undertake the increasingly difficult and dangerous task of protecting our communities. But every person is responsible for and judged by his or her own actions. Neither guilt nor virtue may be inferred simply by association.
All right, so that was the Ohio Attorney General there listing those charges against Coy. Joining us today to break this all down, Julie Rendelman, Law and Crime legal analyst, as well as Bremner, trial attorney. Thank you both for joining us today. Julie, coming out to you first, what's your reaction to the charges there by the Attorney General? We're talking about the felonious assault, commission of a felony, murder in the commission of a felony, and then those two counts of dereliction of duty.
So I wasn't completely surprised. I think we all saw this coming down the pike. I've watched the video numerous times. I think one of the things that's still in question is his partner could not recall whether or not he yelled out to Andre Hill beforehand. And so that is a factor to determine whether or not he really thought he had a gun. And if he did think he had something in his hand, whether or not he announced himself and asked him to drop it before he proceeded to shoot him, as he did. I think the dereliction of duty is pretty clear. I mean, they're mandated to put on their body cameras immediately. And the only reason we have captured what we did is because the body camera naturally goes on automatically about, I think, 60 seconds before. That's why we don't have the audio sound, but we should have had what he said and the video, but he had unfortunately not put it on. And that's why we're looking at dereliction of duty. So I'm not surprised by the grand jury's decision. It will be interesting to see what the officers' defense attorneys will raise in terms of what their defense is as to his actions on that day.
And we'll get to that later on in the show from his defense attorney. But Anne, coming to you after listening to the Attorney General on the charges against him, your thoughts?
Well, I have to preface my thoughts by saying that I've defended police officers for decades, including Portland, Seattle, Chicago. Just finished a virtual trial defending the police in the use of force case. So looking at the perspective from the police officer, you don't look with 20/20 hindsight. The question is, was it objectively reasonable at the time? And officers have to make split-second decisions all the time, and that's going to be his defense. He thought there was a gun. Was that belief reasonable? Was it objectively reasonable? And did he act on that belief? But he's indicted, and so it's a very tough case. Usually you see these in civil cases. As we know, it's very rare to see criminal cases against police officers.
Absolutely. And the family's attorney, who's Ben Crump, he's been speaking to the media about this. He's also talking at a city council meeting because they are considering trying to introduce and create some new law for this. He, again, has recently spoken out about that law. Let's listen to that.
This bold, this effective and responsive leadership in putting forth Andre's law is one that we pray will be able to be replicated on the state level and on the national level. Because as his brother Alvin says so passionately, what good is it having body cameras if you don't use them when transparency is most important? And then his sister, Shauna, talked about how none of those officers seem to have any humanity that was extended to her brother as he lay dying. We are hopeful, even though it won't bring Andre back, that this law will prevent anybody from dying in the manner that Andre Hill was killed 3 days before Christmas, holding a cell phone, not posing a threat, holding a cell phone.
All right. So we had the family's attorney there speaking, and we also had heard from family members of Andre Hill. And of course, the community in this area was completely outraged by his killing. We had many people coming together and speaking out about this. It was another incident of an unarmed black man being shot by law enforcement. So this is a conversation that we are familiar with here, and that really the national dialogue is familiar with, as we've had many of these cases repeatedly. So when we see this again, and when we have body cam footage in this case showing us what happened, sometimes it's cell phone footage, whatever it may be, we get a different look at this and how it all went down. And that's speaking a lot to how this will play out later on when this does go to a trial and he faces the charges here. So speaking off that, Julie, what do you think when you have, these hot topic issues like this with, an unarmed black man, and then the camera footage, and just everyone nationally being honed in on these type of incidents? How does that play out when it comes to court happening in bit here?
So, look, when it comes to a trial, we hope that a jury is chosen that is going to make a decision based on the facts and only on the facts. And even though there might be people outside, yelling and fighting, for the rights of those who have been shot and those who are fighting for police reform. It's imperative that the jury make a decision based only on the evidence. Inevitably, politics always seems to seep in when it comes to any type of matters that we're dealing with. And in a way, it's good because it brings attention to sometimes cases that aren't normally brought before potentially a grand jury that should have been. But sometimes it can go too far in impacting the decision makers by political individuals who are making decisions on these cases. I would hope that a jury at the end of the day will look at this case, look at the footage, and look at whatever evidence surrounds this case to make a determination as to the guilt or non-guilt of this specific individual. Also, one thing I have to add is when it comes to video footage, keep in mind a lot of times, maybe not in this case, the video footage does not capture the entire event. So we always have to be very careful in our rush to judgment in some of the cases, in making sure we really know what we're seeing before we decide what we're seeing is in fact true.
All right. And Anne, as Julie said, a lot of times we get a lot of politic influence into these types of things. And I'm wondering if you believe that in some of these situations, if the officer, or in this case, the former police officer, doesn't get charged with these charges or doesn't get convicted on all of these charges, is there a fear that the outcry of that will just cause more violence or more drama?
Absolutely. And I prefaced my comments by saying that I have represented police officers. I've also been on call for them for many, many years when the shooting occurs. So I'm with the officer, right after any kind of deadly use of force, or have been for a long time with the Seattle Police. And so that's my perspective. And I just put it out there because when you have a case like this, it's basically been out in the media and then in a secret grand jury proceeding, you get a lot of outrage based upon the known facts at the time. But what are those facts? At least out here, we used to have inquests where we had a public hearing in front of a jury on the who, what, where, when, and how of any use of deadly force. And it's in the media, it's broadcast live, everyone has lawyers, and that's all done pre-charging. It seems to me that if we want to make sure we don't have what you described, which is an outcry after the fact, regardless of the outcome, but it could be if he's found not guilty, there's even a bigger outcry. Why not be transparent and introduce the evidence as soon as you can, so that the public, who has a right to know, and the family, who has a right to know what happened, can basically hear all the facts that are objectively presented, or at least seemingly so.
Absolutely. And, you mentioned earlier how you kind of had an idea about what the defense might say here. Can you touch on that again, Anne?
Right. I mean, there's a Supreme Court case on civil cases, but also a standard which basically says, under Graham versus Connor, police officers in the field make split-second decisions all the time. We can't judge what they do by armchair quarterbacking or 20/20 hindsight. So when we look at that, we look at the subjective belief of the officer. Did he think it was a gun? And then, was that reasonable? Was it objectively reasonable, saying in the manner the cell phone was held, with the fact that the way that the person proceeded, things like that made me think it was a gun. So that's what you look at when looking at the use of deadly force by a police officer. I mean, they of course use force and are entitled to do so and privileged to do so and have a duty to do so in certain circumstances. And the question is, was that a misuse here, and was it a criminal act? And given that he didn't have the body cam on, given that he didn't render aid, given that he didn't tell his partner about the danger of a gun, those are all facts clearly against him. But that has to be determined, like Julie said, by an objective, fact-finding body, and that's called a jury.
Absolutely. All right, Anne, Julie, thank you both. Coming up after the break, we're going to hear from Coy's defense attorney. So we will be able to talk more about what Anne was just speaking of there, hearing directly from that attorney after this. Stay with us. And welcome back to the Law and Crime Report. We have more now on the former police officer, Adam Coy, who's facing charges after killing an unarmed black man in Ohio. Now, Andre Hill was shot by Coy walking out of a garage on his cell phone back in December. Our own Anjanette Levy interviewed Adam Coy's defense attorneys. Let's listen now to what they said.
Mr. Hill was not compliant with some verbal orders that my client gave. And then my client ordered him to show his hands and come out. And then when he came near the car, Mr. Hill came near the car, his right hand was down low. My client couldn't see it. His left hand was up high with a cell phone in it. So as soon as Mr. Hill came across outside of the bumper of the car, my client saw a round silver object in Mr. Hill's hand, and he honestly believed that that was a silver revolver. That's when he announced gun, 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 step back, and in protocol and shot.
You have to view it through the eyes of a reasonable police officer. That is the objective standard that Graham v. Connor dictates, but the subjective standard is that the officer must be in fear for his life. And yes, that's what we're saying, that Adam Coy was in fact in fear for his life, that when he saw Mr. Hill's left hand come up with the phone, he was focused on his right hand. And at the time when his right hand came up, he believed that it was a revolver. And because of that, that's when he made that split-second decision to shoot.
All right, so we hear from both of his attorneys there, and obviously lately, the most recently, the woman saying that he was fearing for his life. Julie, is that what you expected his defense to be there?
Yeah, absolutely. I mean, here's the problem is, had the body cam been on as it should have been, we would have some of the answers to some of the questions, i.e., did he in fact yell gun, gun? Did he in fact yell out, let me see your hands? Keep in mind, there's another officer who was with him who I believe, if I'm correct, doesn't recall whether or not she even heard him say any of those things. So had the body cam been on, we would have had some of those answers. I agree. It's true. In the video, it is grainy in terms of his right hand. You can't really see it. Now, the question really goes back to the reasonableness aspect. And that's going to be a determination for a jury as to whether or not those set of facts, including the fact that the body cam's off, which some could believe he chose to keep off. I don't believe that's necessarily true. I believe it's more than likely a mistake, but they could interpret that as a purposeful act on the part of the officer that could even help the prosecution even further with regards to their case.
Right, and that's exactly what my head went to first, too, thinking, well, did he purposely turn that camera off or, wait to turn it on, whatever it may be, which I'm sure jurors could be thinking, too. And before we wrap this story up, what did you think of his defense attorneys there?
Well, they were right on in terms of the defense. Graham versus Connor, split-second decisions, no 20/20 hindsight. They're using all of the language that they were going to be required to present in arguments and based on the law to the jury. So the other thing is, I think it's so important that they describe the way that the officer perceived that this could be a gun, because it's not just the object itself, but it's the manner in which that object is used or displayed. So, I've had cell phone cases, I've had remote control cases, I've had squirt gun cases that look like guns, lighters that look like guns. I mean, over the years with officer-involved shootings. And so keep in mind, they're trained, shoot, don't shoot. I mean, basically they're trained, you got to make a decision fast. You got to assess the situation quickly. So I think what the defense has done was basically well done in terms of preserving defenses and defending their client.
All right, Angelica, thank you. Moving on now, we have new developments surrounding Jeffrey Epstein and his case. A program that compensates alleged victims of sex offender Jeffrey Epstein is suspending its payouts to those victims because of uncertainty with the program's funding. Now, the Epstein Victims Compensation Program will only hold compensation determination offers until March 25th or around that date. And there are over 150 claims filed for alleged victims so far, and the program has already paid out over $50 million to those eligible. Jeffrey Berman discusses the allegations against Jeffrey Epstein when he's alive. Let's listen.
This conduct, as alleged, went on for years, and it involved dozens of young girls, some as young as 14 years old at the time that they were allegedly abused. As alleged, Epstein was well aware that many of his victims were minors, And not surprisingly, many of the underage girls that Epstein allegedly victimized were particularly vulnerable to exploitation. The alleged behavior shocks the conscience. And while the charged conduct is from a number of years ago, it is still profoundly important to the many alleged victims, now young women. They deserve their day in court, and we are proud to be standing up for them by bringing this indictment. Combating sex trafficking and exploitation of children is a priority for this office and for the Department of Justice, as the sexual abuse of a minor can have devastating effects on victims, often lasting for years. That is why my office will not rest until perpetrators of these types of crimes are brought to justice. Victims' voices, including the many voices of Epstein's alleged victims, must be heard.
All right, so that was the Attorney General there in New York. That, of course, was from when Epstein was alive. Later, he was found dead in a federal detention facility in August. That was in 2019, and that was all before he could be brought to trial, and he had pleaded not guilty to any of the charges. Basically, the compensation program is saying that they can't give their compensation in a timely manner. It's not completely funded right now, so they don't want to mislead anyone. So they're suspending these offers because the people that are receiving them deserve this transparency. And I'm reading a line from the press release here. It says that the victims need to know of this change in the way that the program is operating. They cannot be kept in the dark about it. So I am not familiar exactly with how the legal issues around this can be argued and how they unfold, but is the amount of claims that were filed maybe the problem here, that the organization didn't know that there would just be so many, therefore they don't have as much money as they thought they would, Julie?
So it's not that they don't have the money. They have the money. It sounds like what they're saying is the money is not liquid. One of the excuses they give is that he has property that, because of the pandemic, can't be sold. And so it's slowing things down. So the suspension, I don't know that it necessarily means it's not going to reopen. I think that, their argument is, A, they didn't expect so many people to come forward with these claims. And then 2, because of the pandemic, it's slowing down their ability to fill this fund with the money needed. And so, the argument on the other side is, how the heck didn't you know that this would be, how many people would be coming forward, and how did you not know to make sure that there were enough funds, kept liquid to keep this going. So I expect that we'll see additional funds coming. I'm just not sure when.
And, looking at this from a more zoomed out view, and the large scope of this story, there were many accusers that came forward, and we had, names and lists and women who spoke.
Right.
But now with this compensation fund, it seems like there were plenty more people too. And there were just maybe so many that the fund didn't realize how many were out there.
Exactly. I think that's exactly right. I mean, we saw there 150. And what we've seen in the coverage of this case and in the indictment that came out of the Southern District of New York, it was pretty limited. It was vague, but limited. So also I understand this is from a mediator. So the question on enforceability that you raised earlier is a good one in terms of, how do you put teeth in this? How do you make sure that those assets are available? I mean, they're saying in the Virgin Islands that there are assets available. Obviously, he had vast wealth. It's commendable, though, that they've gone through with the mediator and tried to compensate as many of these victims as they can. They just need to keep going.
And what does this mean for those victims and their rights?
Well, it's not clear to me at this point. Are they saying, I'll take this money and then I'm going to forego my ability to sue the estate? Or are they basically saying this is an interim payment, but I still can preserve my rights? I mean, we don't have access to that mediation agreement. But we saw a fund with Weinstein, of course, and now we've seen a fund with Epstein. And I think there was a suggestion from Gloria Allred that there be one with Bill Cosby, but I think he declined. But this may be the wave of the future for these prolific, pedophiles and sex offenders, that there's a fund out there and that people can get access to the money, short of justice in a courtroom, but at least get access to funds.
Absolutely. And any final thoughts about this? I mean, I know, as we said, he pleaded not guilty to these charges, and obviously we won't see a trial for this, but this is really an interesting thing to watch, because it seems like with this story particularly, even though he's dead, there still seem to be new developments happening constantly and new headlines coming out of everything surrounding Jeffrey Epstein, Julie.
Yeah, no, obviously Miss Maxwell is still, in the spotlight with her pending case. I also think, keep in mind, when it comes to the fund, individuals come forward, but you still have to vet them. The fund has to vet them to make sure they are in fact victims of Jeffrey Epstein before they can give out those funds. So that is also something that can slow down the process. I just wanted to add that as well.
All right, Julie, Ann, thank you both. Taking a break right now. When we come back, more of today's headlines. Stay with us here on the Law and Crime Report.
The men and women of the FBI will leave no stone unturned in this investigation. Since these events, the FBI has worked hand in hand with the United States Attorney's Office and our law enforcement partners here in D.C. and across the country to arrest and charge multiple individuals who took part in the destruction. In 6 days, we have opened over 160 case files, and that's just the tip of the iceberg. The significance of this investigation is not lost on us. This is a 24/7, full-bore, extensive operation into what happened that day. We cannot do our job without the help of the American people. Since our call for tips, videos, and pictures, we have received more than 100,000 pieces of digital media, which is absolutely fantastic. And we are scouring every one for investigative and intelligence leads.
And welcome back. That was acting D.C. U.S. Attorney Michael Sherwin speaking about the rioters who breached the Capitol. Jacob Chansley was one of the infamous ones. He was all over headlines after that day. He was shirtless, the man wearing a fur hat with horns. Well, he is still in jail as he awaits trial on his 6-count indictment. And federal judges are now allowing him to keep up his diet behind bars. A U.S. district judge found that if kosher and halal meals can be provided to incarcerated people, so can a shamanic diet. He is known as the QAnon shaman. So he has, since he was incarcerated, he's been consistently demanding organic food on his grounds of what he says are because of his religious beliefs. So this judge is now saying, okay, he can keep up this shamanic diet. I have to get your opinion on this first, Julie. What do you make of this ruling?
So it is true that the Department of Corrections accommodates individuals for when it comes to their food, when it comes to religious beliefs. We see that in Judaism. We see that, as we talked about, in terms of halal as well being provided. The issue here that's unique to those other issues is that the government has investigated, and there seems to be no indication that his religion requires the food that he's requesting. And so it does seem to be broadening the scope of what the Department of Corrections is required to do. At the same time, the government may be saying to themselves, you know what? Let's just give him the food he wants, because in a sense, you don't want an appellate issue. You don't want a civil rights issue. You don't want anything to come of just simply not giving him the organic food or whatever food he wants. And so it's, in a sense, easier not to fight it.
Interesting. And Ann, I'm curious on your take on this. I'm told that other inmates in federal detainees and things like that have been served pork, like if you're Muslim, and in some situations, it hasn't always been followed, even though there are these religious beliefs in place there.
Well, and There are a couple of things. Of course, he has a First Amendment right on his religious beliefs and to be able to exercise those. And then there's a congressional act on this. What the judge said, as I understand it, is I can't find a case that says that that you can go and say, is this a religion? Is this not a religion? Are these beliefs legit? Are those beliefs illegit? Therefore, I'm going to grant the request. Also, he would have had to have been transferred if the court hadn't so ruled. But it's kind of like you look at this, during all the, the controversy about Christmas years ago, and I think it was Seinfeld had, the Festivus for the rest of us. I mean, what is his religion? What was he expressing at the Capitol? What are his rights? So people look at this and they're kind of aghast, like, hasn't he already cost us enough money? Isn't he, really basically using a lot of drama to get attention to himself again? Or is this in keeping with his First Amendment rights and an act of Congress?
Right. And as we know, the raid on the Capitol left 5 people dead, including a Capitol police officer. It delayed for hours, but did not stop, obviously, the task that Congress had that day, which was certifying the state's electoral votes for President Joe Biden. So if you look at, the magnitude of all of this and everything else aside, this issue is his crime here is maybe the bigger topic of discussion, not necessarily
right.
what he's going to be eating in prison. Of course, as charged, he would face, I think, 28 years in prison. So it is sort of maybe a frivolous thing to be demanding of the jail here while you're behind bars, but obviously one that is going to continue to be talked about and looked at as we go on with this story. We're going to switch gears right now. We want to head on to our next story, which is the suspect that was indicted in the killing of the actor Eddie Hassell. So a teenager has now been charged. 18-year-old Dejon Antine is facing a capital murder charge for Hassell's shooting death on November 1st of 2020. Police say that Antine was trying to rob Hassell outside the apartment where his girlfriend lived around 2 o'clock in the morning. Surveillance video showed a black man fleeing the apartment complex and then driving off in Hassell's girlfriend's car. Officers found Hassell suffering from gunshot wounds and died at the hospital. There's no word yet on the motive here, but this is a sad story. Hassell had appeared in Lifetime movies, NBC regular programming, and many other things as an actor since he was a teenager. So my question here, Julie, I'll come out to you first. This is a capital murder charge, an 18-year-old. What could he be looking at here for his penalty?
Well, look, I mean, I believe this is Texas. I could be wrong, so I believe that we're talking about the death penalty. The interesting thing, just so we're clear, is that it's not even just that he's 18. I think he had just turned 18. I think 3 days before, and certainly by no stretch of the imagination am I in any way, shape, or form minimizing the conduct. If in fact he is the person that is responsible for Eddie Hassell's death, but one of the things that always has to be considered is the age of the individual and their background. Is this someone that had committed crimes before? Is this the first time this crime was committed? And so I think we're going to learn a lot over the next several months, probably even potentially years, before we ever get to any type of resolution or even trial.
Yeah, absolutely. And this is one of those incidents that obviously garnered national attention because it was, a celebrity in some sense, a famous actor here, but also because this is just, unfortunate and very sad. And as I said, we don't know of a motive right now, and police have not said anything about a motive. So, Anne, as Julie said, I mean, this is something that we're probably going to continue to hear new developments about as this all unfolds, and of course, as investigations continue, right?
Right. And you look at a case like this, and I think Julie raises a good point. I mean, especially in a death penalty case with somebody as young as he is, there are some defenses out there in these cases based upon the development of the brain and when someone's young in terms of their capacity. I mean, we've seen these in death penalty cases. We see extreme defenses, of course, in death penalty cases. But it's brought attention, of course, to carjackings that probably happen all over the country. But this is a famous actor, and this individual, we don't know his criminal history. That'll factor in. But it is Texas. And if you've got a death penalty case in Texas, that's a very serious matter. And we'll be hearing about it as time goes by, but we just don't know enough about this individual to see what those defenses could be.
Absolutely. And with a capital murder charge in Texas, I mean, this is an 18-year-old, so that means he would be tried as an adult, correct?
Yeah, absolutely. It doesn't, juvenile jurisdiction, of course, starts, it's in a heartbeat, you turn 18, there's no more jurisdiction over you in juvenile court. And so he missed it by 3 days. However, we all know that he probably would have been tried as an adult regardless under the age of 18 because they have what's called a decline hearing or an automatic decline where they decline juvenile jurisdiction in a serious case like a homicide and or where there's priors. And then the jurisdiction favored is adult.
Okay, we'll get back to you after the break, Ann. We got to take our break right now, and we come back more coming up here on Law and Crime. And welcome back to the Law and Crime Report. A former gubernatorial candidate pleaded not guilty to murdering a 12-year-old girl back in 1984. We're talking about 69-year-old Stephen Dana Pankey. He's accused of kidnapping and murdering Janelle Matthews after she went missing from her home. Flash forward to 2019 when her remains were found more than 30 years later. Police then were able to lead themselves to Pankey. And over the years from when she went missing, there was some creepy behavior coming from him. Having related to this case, he had gone forward to police with information. He had posed as a priest trying to get more information about this case. So they kind of, it seems like, always had their eye on him. He did, though, obviously always deny any wrongdoing. And as I said, he pleaded not guilty to her murder. But he is charged. He is charged now. So this is a very interesting thing, you know, happening 30 some years later. And what's your reaction to this?
Well, first, let me say what I was going to say earlier is that juveniles are exempt from the death penalty. So I want to make sure that your viewers, heard that in connection with the last story. But what an amazing thing to come out after all these years and have the evidence to charge him. He made a lot of strange statements, including his own son was killed. And he tried to tie it to this case. They were in the same church. There are all kinds of different things. But also, I thought it was interesting what his lawyer said, which was he's just being charged because he's irascible and has a prickly personality. And I'm like, I haven't seen that many people charged just for those reasons.
And there is a trial scheduled here for July 15th. So honestly, that's not too far out. And the defense, I believe, is trying to change the venue because the location of where this happened, they're believing they wouldn't be able to get a fair trial there. Julie, what do you make of that?
Yeah, I mean, it's not unusual to ask for a change of venue, particularly when you're choosing jurors, especially in smaller communities where everyone knows each other, let alone that everyone's read something about this case. And particularly if he, as is alleged, inserted himself into the investigation, they're going to even know even more about him. And so it's not surprising that he'd ask for a change of venue. At the end of the day, the judge is going to have to make a determination as to whether or not they can, in fact, get a fair and impartial jury in the community that they're in. Sometimes it takes starting the jury process to make that determination, because sometimes once you start, you realize that people just know way too much about the case in order to get that fair trial. But we'll see what happens.
All right, Julie Ann, let's switch gears now to our last story of the show now. A newly elected state representative in Missouri is charged with selling fake stem cell treatments and claiming that they're a cure for COVID-19. Patricia Durgis, who runs multiple health clinics, is accused of running a fraud scheme in those clinics. She's facing multiple federal charges related to medical fraud. She's been removed from committee assignments on the Capitol. And some of her charges are felony wire fraud, illegal distribution of controlled substances, making false statements. And this was all revealed just this week by federal prosecutors. She pleaded not guilty in her first appearance in front of a judge and was released without bond. She is set for a jury trial in March. This is a very interesting case, obviously related to the pandemic and COVID-19 here. Anne, what are your thoughts?
She's outrageous. I mean, to be in a public position like she is and then to do something like this, you know, in the breach of trust. And of course, she's preying on people that are vulnerable and older, presumably. So, you know, she's a 3 strikes already in my book, out.
Right, absolutely. And, you know, Julie, I'm curious your take on this, because she's saying that during all this, she's going to continue to work and, you know, still she's saying that she's innocent until presumed guilty. So she thinks, you know, I did nothing wrong here.
Yeah, look, I mean, she is presumed innocent. And so, you know, I don't want to get ahead of myself, but if in fact the evidence is as they depict it to be, as Ann said, it's pretty despicable. I mean, you have to realize that we are in one of the most trying times of our lives over the past year, and people are desperate for an answer and a cure. And some ability to be able to function in life, particularly those who are more vulnerable. And the idea that someone would mislead individuals into believing that somehow what they had or what they took from her would enable them to, you know, to be free from COVID is absolutely just reprehensible.
And we know that she has some sort of assistant physician's license in the state. What that allows her to do, I'm not sure. But if she is indeed deemed guilty, I'm assuming that will be revoked from her. And there's not only going to be a fallout from that, but also a political fallout here. Julie?
Yeah.
Well, yeah.
Sorry. I don't. You can take it, Ann. Go for it.
Oh, no, that's all right. I was just going to say that they should do an emergency interim suspension. But go ahead, Julie.
No, I was going to say the exact thing. I was going to say I'm shocked that someone hasn't stepped in from one of the medical boards to at least suspend her license temporarily until there's a determination as to whether or not she is in fact guilty. So I'm surprised that hasn't happened, but I wouldn't be surprised or shocked if that does happen in the near future.
And aside from her and her conviction, if she is convicted, this could also bring other lawsuits coming from the people that she administered these medications to, right, Anne?
Oh, absolutely. She's got to have insurance, you know, and so yes, I mean she's a target from a lot of different directions, I guess, people and even the board of health, etc. All
right, Anne Bremner, Julie Rendelman, thank you both for joining us today. Back to our regular scheduled programming after this here on Law and Crime.